Okay, if it's all right with everyone, we'll get started. Good morning. My name is Joan Burda. I have a solo law practice in Lakewood, and I'm an adjunct professor at Case Law School, where I teach LGBT legal issues and wills and trusts. One is exciting, the other one not so much. And of course, the non-exciting one is I do that at 8 o'clock in the morning, which is a big hit with students. What we're going to talk about today is post-Obergefell, the legal issues that continue to exist and plague the LGBT community following the 2015 Supreme Court decision that granted marriage. And in a nutshell, that's all Obergefell did, was now gay people can get married. When Obergefell was issued on June 25th, which I don't know if people understand, but most of the gay decisions, the gay-related decisions that came out of the United States Supreme Court, all came out on the same day, different years, so it's now known as Gay Day at the court. The anti-gay decisions don't come out in June. They come out at other times of the year. It's a very strange phenomenon. I'm sure the justices sit around and plan that. After Obergefell was decided, the donations to LGBT national organizations, Lambda, GLAAD, and National Center for Lesbian Rights, dropped off. People said, okay, we've got it, it's done, it's finished, we've won, we can now start contributing money to other causes. Little did they know that, and actually I think it's probably because most people didn't read the decision, they didn't realize that because Obergefell only dealt with marriage, that there remains a plethora of issues that continue to plague the community. For example, last week in the New York Times, there was an article about how real America, in quotes, became queer America. And that in rural counties, and the author talks about Georgia, Alabama, that gay people are fully accepted and in their communities. And I read that, and I asked my class to read it, and I said, did you see anything odd about that? And they said, well, it's a little naive. Because while there might be local ordinances that have that prohibit discrimination based on sexual orientation and gender identity, state law does not. State law and will still control. And so I thought the author was overly optimistic. It's an interesting article to read, and I didn't read any of the comments, but it's an example of how people are still missing the essence of what's continuing to go on. For example, SCOTUS in the Obergefell decision didn't address employment or education or public accommodations, housing, or credit. And by the way, since we're a fairly small group, if you have questions or comments as we're going through, we've got an hour, by all means do it. I prepared materials that I believe were posted for everyone to download. There is absolutely no way we would get through everything, but I'm a lawyer, I write, so I just did that. So all these other areas that the Obergefell decision, and whether it's Obergefell, Romer, Windsor, none of them addressed, that remain a problem. And with the current administration accelerating anti-gay rhetoric and actions on part of federal agencies, the Justice Department, and sometimes it's just, we won't do something, we won't protect, we won't take action, it has contributed to the problem. Ohio is one of 28 states that has no protection based on sexual orientation and gender identity. When Governor DeWine took office, he issued an executive order that includes sexual orientation and gender identity as grounds for non-discrimination, but that only applies to state employees. When Kasich took office, there was an order in place that said no discrimination based on sexual orientation and gender identity. Kasich issued his own and erased gender identity. So you could discriminate during Kasich's administration against transgender individuals or gender nonconforming, genderqueer individuals, but you couldn't discriminate based on sexual orientation. Now we have a new governor, and once again we have a new executive order, and all the protection is put back in, but only for state employees. Senator Nikki Antonio has once again, for the 7th time, introduced her Ohio Fairness Act. It's Senate Bill 11, that would add sexual orientation and gender identity to Ohio's non-discrimination law. And that's what we need. To limit it to executive orders, everything's at the whim of whoever holds the governor's office at any given time. The other problem with Obergefell is that it really piqued the interest of the anti-gay crowd. They saw that as an assault on Western civilization as we know it, that the end of time was coming, all because gay people could get married. My spouse and I were married in 2010 in Vermont because we could get married in Vermont. So we got married, and we came, as we're driving back home, we're going through New York, we're recognized, we're going through Pennsylvania, marriage was recognized, we crossed into Ohio, suddenly we are legal strangers to each other. It was a very strange experience. Windsor came out, and suddenly the federal government had to recognize the marriage. So we immediately contacted our tax preparer and said, how does this affect us? And she said, well, you can amend your tax returns for the past 3 years. And so we started getting checks from the federal government for the refunds that we would have gotten had we been married when we filed our taxes, and now that we were. So that was interesting. We had other friends who were married, and they had to pony up some money, so they didn't file an amended return. But state legislatures around the country, and also in Congress, are introducing legislation that is directly antagonistic to the LGBT community. The most famous, probably in recent memory, is the North Carolina legislature on the bathroom bill, telling you that that you had to go to the bathroom, use the bathroom that related to the gender that you were assigned at birth, because they were convinced that all the men were going to start putting dresses on and going into the ladies' room. I was going to North Carolina shortly after that legislation passed, and I wrote the governor and asked if I needed to bring a note from my mother to ensure that I was allowed to, like, go to the bathroom, pee in his state. I never got a response, which didn't surprise me, but I found out later I wasn't the only one to ask the question, how do you tell? That's as a preliminary, that we have these ongoing issues. You have a situation, we've got the Masterpiece Cake Theater, the Masterpiece Theater cake, the Masterpiece Cake case that came out of the Supreme Court, where the courts, if you read the cases, the decision's kind of strange. It's one of those decisions where you wish you were the fly on the wall in the conference room when the justices were all talking about it, because they didn't actually decide it. All they said was the commission wasn't very nice to the baker, and that some of the commissioners seemed to be criticizing his religion, so they sent it back. And they said, try again, which to me says that they just don't say anything about his religion and just refer to Colorado law and say that you're violating Colorado law, so you still lose. I anticipate that the cake will come back up, that it will rise again, and SCOTUS may get another bite at the apple. There are several other cases currently pending, but we also need to look at what the court is doing with lower court decisions or with state court decisions. For example, in Texas, there were 2 men who filed suit against the city of Houston because Houston had passed an ordinance that would grant full marital benefits to married same-sex couples, and these 2 guys were apoplectic about it. So they filed a lawsuit, and they lost. and it went to the Texas Supreme Court, and this is the pigeon case. And the Texas Supreme Court agreed that they should not win, that they had no basis for this lawsuit. And then the Texas Supreme Court, several months later, took a mulligan and decided and just heard the case again. Nobody asked them, they just took it up again. And this time said, oh yeah, it was a V8 moment. Gosh, what were we thinking? Of course that Houston cannot give the same marital benefits to same-sex married couples as they do to heterosexual married couples, because the Obergefell decision did not require it. And if you read Obergefell, there's nothing in the decision that where the court sat down and you must also do you have to do this, you have to do this, you have to do that. The defendants in the case, Houston, took it up to the United States Supreme Court, and they refused to hear the case. They said, no, we're not going to grant cert, and they just sent it back down. So in Texas, the cities can provide marital benefits for heterosexual couples and deny the same benefits to married same-sex couples. Yeah.
What standing did people have throughout the case?
They were taxpayers. And my tax dollars are being used to violate my strongly held religious beliefs, because I don't believe that same-sex, that gay people should have the same rights as heterosexual people. That's it in a nutshell. And the Texas Supreme Court reversed itself without being asked to, which is an unusual situation. I'm afraid I don't have the site for the pigeon case with me, but if anybody wants it, let me know. And I will get it to you. In fact, I'll just send you the decision so you don't have to look it up. But let's go into some of the issues that are ongoing problems for the LGBT community. And they come down to a couple of areas, primarily family law. There is still an opposition to, or questions as to how the law will apply to same-sex couples who are raising children, both unmarried couples and married couples, because not everybody's going to get married. Some people won't because they are receiving an alimony from a previous heterosexual marriage, and if they get married, they lose that. Some of them have other reasons that they just don't want to be married. I got a number of couples who have been together for 40 years, and their attitude is, why? They talked to their financial planner, they talked to their tax preparer, and there was no benefit to getting married other than having the piece of paper. But with people with children, that's presenting an ongoing problem. For example, in Ohio, we have the marital presumption. Child born during the marriage is a child of the marriage, but it's rebuttable. And we have cases, we refer to them as LBB cases. Anybody ever heard the term? Lesbians behaving badly. That's when you have a couple of lesbians that were in a relationship, they have kids, and then they decide they don't like each other. Whether they're going through a divorce because they got married or they are just unmarried couples and they're separating, they don't behave well. It's like the heterosexual divorce on steroids at times, because it's always, these are my children, not your children, certainly not our children. And the courts are gradually getting better at it. If the couple's married, there's a framework they can work with. The marital presumption, however, creates a problem because in many cases, the couple got married in 2015, but they've been together since 2000. So the children were all born before the marriage. Marital presumption doesn't apply. How do you establish parental rights? Most clients will say, I want a birth certificate with both names on it. The birth certificate is an administrative document. It does not convey legal rights. Okay. I'm sorry, I thought somebody brought a dog. I was like, cool. They can't get the non-biological, the non-genetically related parent cannot get legally recognized as a parent just because of a birth certificate. If that were true, then there'd be any number of men in this world who would suddenly become fathers because some woman put their name on the birth certificate. And we've all seen that on occasion where the guy's like, I don't even know her. But she wanted to put somebody down because they asked at the hospital. So explaining to clients that the birth certificate doesn't give parental rights. Ohio, the status of second parent adoption, which is when two people of the same gender will adopt a child and the biological or genetic or the birth mother, we'll just keep it with women because it's easier, the birth parent will not lose their parental rights. So theoretically, I mean, traditionally, if I was to adopt your child, you would lose your parental rights and I would become the mother. Second parent adoption doesn't happen. Ohio, it's up in the air. I keep waiting for somebody to test the waters because there are second parent adoptions being granted in the state of Ohio. We know that for a fact. We just don't know where. There are probate judges who see nothing wrong with that. We also have a case called In re Bonfield. And if you look at the materials, the citation is in there. Bonfield came out in 2002, and it involved a lesbian couple who were raising 5 children together. One of the women was the legally recognized mother. She had adopted all 5. They were all special needs kids. She had adopted the 5 kids, and they wanted to execute a shared parenting agreement. And then they went to juvenile court, and they said, Judge, we want you to accept this shared parenting agreement because we want it to be a court order, which will bring in full faith and credit. The juvenile court in that case said, I can't do this. I have no jurisdiction. So they took it up on appeal, and it finally ended up with the Ohio Supreme Court. The Ohio Supreme Court ruled in Bonfield that said, the court said, there's nothing wrong with this, except you can't use the word parent. You can use shared custody agreement, but you can't say shared parent because parent is a legal word of art and it has a specific meaning, and 2 people of the same gender cannot both be mothers to the same children. And the court, when it originally issued, and that's keyword originally, issued its decision in Bonfield, said second parent adoption is not permitted in the state of Ohio. Well, the plaintiffs filed a motion and asked the court to reconsider that sentence. And the court did and reissued. The Ohio Supreme Court took a mulligan. I've never seen that happen before, issued a new decision and erased that sentence. So according to the Ohio Supreme Court, second parent adoption is not prohibited. There's just nothing in the statute that says it is. The question becomes then, if somebody wanted to file for a second parent adoption and take it up, how would the Supreme Court rule in light of Bonfield? There is a 9th District Court of Appeals decision that refused to grant a second parent adoption to a couple in Akron. And at the time, the child was, I believe, 12 years old. They petitioned the Supreme Court, and the court didn't grant cert. That predates Bonfield. So somebody at some point is going to ask. One of the ways to get around it, and this started in Franklin County with the 2 lawyers down there, Leanne Masucci and Carol Fay. They approached, Franklin County has a family court, which includes juvenile court and domestic relations. And they approached the judges and asked if the judges would entertain parentage actions that would allow, so far they're only doing married couples, that would allow a married couple to come in and get an order from the court granting full legal parental rights to both parties without having to go through an adoption. It's been going on in Franklin County for the past several years. It's been very successful. Leanne and Carol have exported it to surrounding counties, and you can now do that here in Cuyahoga County. Joy Saverin and I approached Judge Sweeney a couple of years ago and briefed the issue to her, gave her sample pleadings that people could use, and asked if the court would accept that, and she said yes, and the court has been doing that. Unfortunately, not all the judges are online, so if there's at least one judge that will not grant them. And so if you draw that particular judge, we're just recommending that people dismiss and file for a step-parent adoption. Clients, married same-sex couples, particularly the lesbian couples, hate the idea of a step-parent adoption. I shouldn't have to adopt my own children, which is true, and that's where you cajole and you talk to your clients about getting real and say, yes, I know it isn't fair, I know it isn't right, I know it isn't nice, but do you want to argue about that, or do you want to get legal rights, parental rights regarding your children? The probate court here in Cuyahoga County will not grant second parent adoptions for unmarried couples. Neither will they look at kind of finessing the step-parent adoption for unmarried couples. Their attitude is, if the court's attitude is, if you want to adopt, then get married. But we're working on this. We're trying to explain things to the court to let them know of the hardship that is imposed on the children. Not looking at the adults. The adults can take care of themselves, but the children are the ones that are at risk. The other problem with marital presumption is not every state recognizes it. So if we rely on marital presumption and somebody goes to New Mexico and something happens in a small town, Truth or Consequences always comes to mind, because I always think that's an interesting, it was an interesting game show, and it's a little town in New Mexico. If you go there and you get somebody who doesn't like gay people and they take the child from the non-biological parent, where does that leave the kid? The kid gets put into the system because they don't recognize marital presumption, and the couple cannot prove formal legal parental rights on the part of both. The other issue that comes up are pre-existing legal relationships. There was a time when, and I've had several clients who did this. They would go with various partners, and they would go to various states, and they'd get a civil union here, and then with somebody else they'd have a domestic partnership in California, a civil union in Vermont. They'd go out to Seattle on vacation with the third person, and they'd get a civil union out there, or I'm sorry, domestic partnership in Washington State. And then they show up in the office and they're planning on getting married to somebody else, and explaining to a client that, yeah, that's fine, but don't do it yet because you have to dissolve all of those pre-existing relationships, comes as a big surprise. Comes as an even bigger surprise for folks who went out to Washington and thought Seattle was a great place, got their registered domestic partnership, and you have to break the news to them that, congratulations, it's not a domestic partnership. You were automatically upgraded to marriage in 2014 by the state of Washington, and you may or may not have been knew about it. Delaware, Rhode Island, Connecticut all did the same thing. They upgraded to marriage. And if you went there, if a couple went there and did not know this, they may not know that they're married. And if they've married somebody else, they may not know that they're in a bigamous situation. And if they ever win the lottery, they're going to have a problem because their still spouses are all going to start coming out of the woodwork. There was a case here in Cuyahoga County a couple years ago. It's referenced in the materials. Judge Gold had it. She wrote a really good decision. From a lawyer's standpoint, it's the kind of decision you never want to get, because throughout the decision, she kept saying that the plaintiffs or the defendant's attorneys failed to raise any legitimate legal arguments supporting their position. You really don't want to see that. And what happened in this case was there was a lesbian couple. They went to Canada. And Canada, of course, allowed same-sex marriage before many of the states in many United States did. And they came back to Ohio. So they've always lived in Ohio. And they had a child born during the marriage. Well, then they decided they didn't like each other, or rather the birth mother didn't like her partner, her spouse. So they split, and she started dating the children's pediatrician, also a woman. Then the birth mother decided that she didn't really need to talk to a lawyer. She did her own legal research, always a bad idea, and decided that Ohio did not recognize the marriage, the Canadian marriage, therefore it was invalid. And they went to New York and got married in New York. Problem with that is New York did recognize the Canadian marriage, number one. Number two, when she filled out the marriage license application that said, have you ever been married before? She said no. And of course, you sign all those things under penalty of perjury, so she lied. They got married in New York, came back, and it wasn't long before the pediatrician was no longer enthralled with her bride. And the Monday, Obergefell came down on a Friday. The following Monday, she filed for divorce. Because now marriage was recognized, she could get a divorce. She didn't have to worry about going elsewhere. First spouse also files for divorce. That's when the Gold decision comes out, because the defendant in that case is saying, wait a minute, it was an invalid marriage. And she was like, no, it's not invalid. It was unrecognized. There's a difference. And that's something that a lot of lesbian and gay couples who got married to various and sundry other people haven't remembered. And I find that there are lawyers who are not asking the questions. Have you ever entered into any other legally recognized relationship? Before Obergefell, I would tell people, go to Vermont or the District of Columbia if you wanted to get married. This is pre-Obergefell, because DC and Vermont have a statute that said, that provides if you are a non-Vermont resident and you live in a state jurisdiction that does not recognize your marriage, you do not have to establish residency to file for divorce in either DC or Vermont. Vermont has an additional caveat that said if you have minor children, you have to be a resident. My argument was always, if I'm a resident of Ohio and I go to Ohio, to a juvenile court in Ohio, then Vermont would not have jurisdiction because I have another court in child's home state that took jurisdiction. So UCCJEA would come into play there, and I think an argument could be made. Unfortunately, everybody wanted to go to New York. And I said, fine, go to DC, then take the train to New York, have the party at the plaza, but do the deed in the District of Columbia, hedge your bets there. And so there are people who may have entered into all these various relationships, and they may be in states where you have to establish residency to dissolve them. And I don't, as far as I know, the domestic relations courts in Ohio will not dissolve a civil union or a domestic partnership. I assume that you could go into general division and see if the judge there would dissolve it on a contract basis. But nobody really knows. And there are a lot of people out there that have these, and they're just not doing anything. The length of marriage, if we go for divorce, the length of marriage is also in question, because if somebody got married in July of 2015 and they're getting divorced in 2019, the marriage lasted 4 years. But that couple may have been together for decades. So the question is, when you're dividing property, is it the length of the relationship or just the length of the marriage? And that's a question that's being argued about in courts throughout the state, because there are no definitive answers to it. Depends on what the parties want or what they will agree to. The other thing that I think is interesting is something called, there are several states, well, strike that. There's one state left that has a reverse evasion statute. Anybody ever heard of that? Know what it is? Anybody? Yeah, these popped up. First with Massachusetts. When Massachusetts Supreme Judicial Court, I'm of the firm belief that every state should have their top court called the Supreme Court and everything below it, a trial court or an appellate court. They have all these different weird names on the East Coast. Anyway, when Massachusetts said that gay people could get married, you had all these folks who ran out to Massachusetts on May 17th, which was the first day you could get married, and they all got married, but they came back to their home state. Massachusetts had, where the marriage would not be recognized, Massachusetts had a reverse evasion statute. That said, it was from 1912. And it said, if you are not a resident of the Commonwealth of Massachusetts and you get married here, but your home state will not recognize that marriage, you are not allowed to get married, and your marriage is void ab initio in Commonwealth of Massachusetts. So you had all these people running off to Massachusetts without realizing that all their effort was for naught because of this statute. Once the Massachusetts state legislature realized they weren't going to be able to overturn the Supreme Court's decision, and they acquiesced to the fact that gay people were going to get married, and Mitt Romney finally gave up the fight, they tackled this reverse evasion statute and repealed it. The most recent iteration in Ohio came in the McKettrick case, which, if I'm not mistaken, is out of the 12th District Court of Appeals, in which it's one of those rare occasions where the lawyers had the law wrong, and so did the judge, and so did the appellate court. It's now been kicked back down in light of Obergefell, and I'm sure that they've just dissolved the marriage and gone on. But the court said that because of the reverse evasion statute, the marriage was not valid. The difference in that particular case was that one of the women owned property in Northampton and used that address on the marriage license application, which would give the basis for issuing the marriage license in the first place. So I think that everybody got it wrong, and had they called GLAAD, which is the Gay Lesbian Advocates and Defenders out of Boston, they would have told them how the law was being handled in the Commonwealth. New Hampshire had one. Wisconsin's really weird. Wisconsin's law makes it a criminal offense for which you can be sent to jail if you leave the state to get married to someone and the marriage would not be recognized in the state of Wisconsin. They just criminalize it, and it's been on the books for years. They just didn't want people going out forum shopping. If you can't get married in Wisconsin, you can't get married anywhere. And if you try it, we're going to put you in jail. The remaining reverse evasion statute is Illinois. Illinois still has one, and it says, paraphrasing, if you're not a resident of Illinois and you come to Illinois to get married and your marriage would not be recognized in your state of residence, domicile, it is that the clerk is prohibited by law from issuing the license. Unfortunately, the clerks didn't know that. So in 2014, when Illinois recognized marriage equality, there was this, Megabus was full, headed up to Chicago with all these people, and they all decided to get married. That statute is still on the books. And if the marriage was void ab initio from the beginning, Obergefell does not resurrect it, because they were never allowed to get married at the beginning. I know of one case, it was a couple in Columbus. They did that. Residents of Ohio went to Illinois, got married, and then they decided to get divorced, and the question was, is that a valid marriage? And we were going back and forth, because one guy wanted the divorce and the other one didn't. And my response in situations has always been that just don't live together for a year, and then it doesn't matter if the other party doesn't want it. But it's something we have to consider. Where did they get married and when? And how did they get their license? And what did they put down on their license? And do they have any of these other relationships? Obergefell just said we can get married. It didn't deal with any of these other legal dilemmas. Assisted reproductive technology. One thing. On adoption, since the issue is nebulous in Ohio as far as second parent adoption, I have sent people to Florida. Florida has done a 180. Florida has gone from, we will never allow gay people to adopt children at all, to there is no residency requirement for a second parent adoption in the state of Florida. You don't even get to go to Disney World because I have several lawyers in Florida, and I refer my clients to them, and they take over. But everything is done without the adopting parent ever being in the state. They don't even have to show up for a final hearing. It's done by phone. They get an order from the state of Florida saying the adoption has been granted. They have never been a resident of Florida, but Florida doesn't have a residency requirement for adoption. South Carolina, their only requirement is you have to be present in the state when the petition is filed. So you go to Charleston, you file in the court, and then you go home. And people can get second parent adoptions. None of those have been challenged yet. North Carolina Supreme Court 10, 12 years ago issued a decision because second parent adoptions were being granted in that state. The Supreme Court nullified all of those adoptions, many of which were granted to non-resident couple or people who were living there at the time, but then moved. So there are people out there who may have had a second parent adoption in North Carolina who don't know that that adoption has been nullified. I have not seen any of those cases yet, but I know that it's just a matter of time before somebody gets mad at somebody else and starts questioning the history. Assisted reproductive technology is an area that is used frequently by same-sex couples, and it presents some unique issues for the LGBT community because you can have a sperm donor and egg donor with a gestational surrogate, and then you have the intended parents. And so the intended parents have no genetic or biological connection to the children or child that has been born. And both parties would have to adopt in order to have parental rights. If the marital presumption would apply if reading Ohio law in that the child born during the marriage, these are the intended parents, but an adoption is still in everyone's best interest because it clarifies things. If you have no connection whatsoever to the child, you don't want to rely on a rebuttable presumption or a piece of paper on the birth certificate. Citizenship issues, immigration, I'm not going to get into immigration today because that's in flux on so many different levels. But there's a case that came down 2 weeks ago. It's called Devash-Banks versus Pompeo. In that case, you had a U.S. citizen, a gay male couple, U.S. citizen, and an Israeli citizen. They're using a gestational surrogate. They had the gestational surrogate carried 2 eggs. One was fertilized by one man, the other one was fertilized by the other one. They had twins. The Israeli dad is the father of one, and the American dad is the father of the other. They moved from Israel, they went to Canada, and then they decided to come home, and the U.S. State Department said, well, we're going to give citizenship, and they're married. We're going to give citizenship to the one kid, but we're not going to give citizenship to the other one. We're talking infants here. So they came back, and the kid was on a tourist visa, which expired. It's like, yeah, deport this, it wasn't even a toddler. It was like 6 months old. They sued, and a federal district court has ruled that the State Department policy was arbitrary and capricious and not based on law or regulation. It was just something somebody dreamt up at some point. And I said, you can't do that because with heterosexual couples, you don't ever even ask. But with this gay couple, you were treating them differently. And the court ordered the State Department to issue this other little boy a U.S. passport. and recognize him as a U.S. citizen. The husband, the Israeli citizen, he's here, gets a green card because of his marital status, and then he can apply for citizenship down the road. But this is a brand new case. It just came down, and I have not heard yet whether state's going to appeal. They probably will, because that's what they do. With the stored genetic materials, this is not limited to the LGBT community, but one of the issues that comes up is who owns the stored genetic materials. It's considered property. If the couple is unmarried and they've been using art to start a family, and one of say it's the eggs of one woman, lesbian couple again, the one woman has donated the eggs, has been used a sperm donor, and the eggs have been fertilized, and they're in storage. She dies. Who owns the genetic materials? You have to look back at the contract. Contracts for clinics are getting better, but you still want to, there's still a lot of them that are doing cut and paste, and they don't hire a lawyer to look at these things. So you'll have one section that the law of California will apply, and another section the law of Oregon will apply, and another section the law of Pennsylvania will apply. And then there'll be something in there that says anything stored in our facility belongs to us. And if you are the donor, then you are relinquishing all of your parental rights to the donated materials. So it's not a simple matter of two people decide they're going to have a baby. From an estate planning standpoint, I think that the estate plan documents need to address any stored genetic materials and what they are going to happen to them after one party dies. Also needs to be addressed if the parties split up, whether it's an unmarried couple or a married couple. You need to address. We need to address the genetic materials, because it will. It can come and bite you at some point in the future. Can a couple that has stored genetic materials, can one of them use it and make the other one a parent against their wishes? Courts are all over the map around the country. Some say yes, some say no, some say it's the only chance that this woman will ever have to become a parent, so her wishes are superior to the wishes of the other prospective parent. I think if we have some type of contractual arrangement as far as the use of this property, because that's what it's considered. If you think of it in terms of, there's a little boy in Texas whose parents were murdered, they died intestate. And he inherited 11 embryos. They're in storage in a clinic in Texas. And that probate must remain open until this kid turns 18, at which point he gets to decide whether he really did want that little brother or sister. The judge in that probate matter had never seen this before, had no idea what was going to happen. And so just said, well, we're just going to maintain the status quo. And the kid can decide when he's 18 what to do with this property. Now, the question will be if the state of Texas, they've tried it before, passes a personhood statute like Alabama just did last November. What rights do those embryos have? And are they no longer considered property, and who's going to do what with them? In Alabama, there was a woman who had an abortion 2 years ago. Her boyfriend was upset. A lawyer has been appointed to represent the estate of the embryo because they have a personhood statute, and they are now suing. Be an interesting case to address. Also need to look at post-mortem extraction and post-mortem kids, children that are born after the fact. The Astru versus Capado case out of the United States Supreme Court says that a state's intestate succession statute will apply as to whether those after-born children are entitled to Social Security benefits, dependency benefits. In Ohio, they would not be if they were born, if they were not in utero at the time of the testator's death, or the intestate person's death. They would not be entitled to an intestate succession if they were born if the pregnancy occurred any time after that. And anybody who's dealt with assisted reproductive technology knows that sometimes the third time is not a charm, and it sometimes can take 4 years or more before a viable pregnancy takes place. Any questions, comments, jokes? Okay, the employment issues, while lesbian and gay people have not been very successful, particularly in Ohio, in getting rights, employment rights against non-discrimination, it's often said that we can get married on a Saturday and be fired from our jobs on Monday because there's no protection. The Sixth Circuit, one of the most conservative circuits in the country, has, however, been very, very kind to the transgender community in employment cases. There are 2 cases from the early 2000s, late 1990s, out of Salem, city of Salem, and the city of Cincinnati, both dealing Cincinnati with a police officer, Salem with a firefighter, in which the Sixth Circuit issued an opinion that said it is illegal and it is discriminatory for a city to fire a transgender city employee. So city employees are covered. I would argue that it extends to state employees on that basis as well. But we've just got a new decision. It's Harris Funeral Home versus the EEOC. It's out of Michigan. And in that case, it was a funeral home that had a funeral director who was transgender. She transitioned during her employment, hired as a, when she was presenting as male, she now has transitioned to female. And they said that she could not continue working for the funeral home because it violated the strongly held religious beliefs of the funeral home owners. The Sixth Circuit stated that that's not a valid reason to discriminate based on gender identity, and that this is based on sex. The EEOC brought the case. This was sex discrimination and is covered by Title VII and the funeral home lost. They have applied for cert. I don't know if the Supreme Court's going to take the case. But if they don't, then we have a decision that for transgender individuals that covers both private and public employers in our circuit. And that was a huge win for the transgender community. The lesbian, gay, and bisexual community is still struggling to get a universal decision. Doesn't exist in the Sixth Circuit. They have repeatedly ruled that the Title VII does not protect against sexual orientation discrimination. There are 2 competing bills in Congress. One will include sexual orientation and gender identity in the Civil Rights Act of 1964, and the other one will not. They will expressly exclude gay people. The U.S. Department of Education has taken action that they basically gutted the Civil Rights Office in the department that provided protection for transgender LGBT youth in schools. They are taking very few cases anymore, and if the same issue comes up on either polar opposite sides of the country, they will not take both cases because they don't think they have to, even though everything's very fact specific. So the Department of Education is no longer supporting transgender students with locker room, bathroom issues. They've rescinded everything that came out of the Obama administration, and I know that some of the local schools here in Northeast Ohio were trying to determine how to best address the matters involving their transgender students, and they've all stopped because they don't have to anymore. They know they're not going to get sued, and if they do get sued, they know they're not going to lose. There's one federal decision that came down last year involving transgender students in the Cincinnati area. Court ruled against them, said that they have no They have no legal rights to use the bathroom of their, once they've transitioned. And now we're also seeing issues with some state legislatures introducing legislation that will prohibit, most recently, I think it was Illinois on Monday, that will prohibit doctors from treating transgender youth. That it will be a criminal offense if a doctor treats a transgender child or refers that child to another doctor, that the doctor can be prosecuted. There is no basis in logic for this type of a legislation, and it's just harmful. We have here in Cleveland the Pride Clinic over at Metro. There's a transgender clinic at the VA hospital at Wade Park. And Henry Eng is the doc who founded the Pride Clinic at Metro. The last I heard, it's something like 3 years to get to see Henry, if you want to actually talk to Henry as a patient, because they're just inundated with the number of people. Puberty blockers can be given to children who identify as transgender. And I often get asked, like, how does a kid at 6 know that he's not a boy? And I've always thought back to when I realized I was a girl. And I was like 3. I remember I was like 3. I knew I was a girl. And if you ask a transgender person, they'll tell you the same thing. I was like 3 and I realized I wasn't a girl. Or some of them are even younger than that. And working with children presents a number of issues. If the kids are being subjected to tugs from both parents, one parent is supportive, the other parent is not. If the child is turned over to the state because the parents don't want to deal with it and they go into foster care, it's what's the rights of the child in foster care to be protected from discrimination by their foster family. For example, kids can't be forced to go to church. That comes as a big surprise to a lot of foster families. It's like, well, we all go to church, and it's like, great, but this foster child does not have to, and you can't force them to do that, and the state has an obligation to protect the child. So that's an issue that's raised up with kids, is what are their rights as far as being allowed to express themselves, how they dress, how they act, the name they used. I had a transgender high school student contact me, and he wanted to, transgender male, he wanted to change his name. And unfortunately, he contacted me after they went to court. People have to understand it's really a lot easier if they talk to the lawyers before they do something, because it's easier to fix it. He went into court and he told the probate judge, this is in Lorain County, and the judge said, why do you want to change your name? The kid was 15. And this young man said, because boys have it better. Well, I often thought that when I was a kid, because boys could go out and get dirty and not get yelled at, and I would. But the judge said, well, you know what? That's not really a good reason to change your name. I'll tell you what, come back when you're 18 and let's talk again. And so he called and he was very upset. And he said, the judge is discriminating against me. And I said, no, not really. It's just that there were better answers for what you could have said. Under the circumstances, I think the judge was fine. Fortunately, he had a rather gender-neutral name to start off with. And I said, just don't use your middle name, which was a very feminine name. I said, just you go by your first name, and you want to get a job, and you want to go in, presenting as a boy. I said, so be an entrepreneur and go out and start your own business. And he had never thought about that. He was like, what? And I said, well, cutting grass, shoveling snow, the things nobody wants to do anymore. I said, I had a kid on the street who used to do that. He ended up with 5 kids working for him by the time he was 16, because nobody wanted to shovel snow or to cut the grass. It's a matter of, as lawyers, and I tell this to my students, we come with myriad experiences, and a lot of this can also come into with common sense. But from a legal perspective, we have to be creative. And it's one of the reasons this area of law is so exciting is because we can be creative. It's not like torts. You know, torts, you got Palsgraf, you got International Shoe, you got all these cases and this long history. In this particular field of law, we don't have a lot of precedent. So we can come up with ideas. When we presented the parentage matter to Judge Sweeney in juvenile court here in Cuyahoga County, before we left, I said, you know, Judge, the other issue that's going to crop up is polyamory families. And she just had this shocked look. She said, I don't even want to talk about that. I don't even want to get into that. And that's what's coming down next. Polyamory families, where you have multiple adults with multiple children, and not all of the adults are genetically, or legally, or biologically related to the children, but they are a family unit. How are we going to deal with that? Ohio is just, they're just plugging their ears and closing their eyes and humming. We don't want to even talk about that. California, you can have 3 parents. California will also recognize polyamory families. I anticipate there's going to be a problem. You have 6 adults, you have 4 kids, the adults no longer talk to each other, and everybody wants visitation. Those kids are going, they're never going to have a weekend to themselves until they turn 18. So where does the rights of the children come into play on that? I get into trouble when I raise that issue with the polyamory community because they say, well, we have our rights. And I'm like, yeah, but I think the kids have rights too. But it's something that we're not talking about. The legislature is ignoring all of these issues. I'm not sure I want this legislature to address them. I would love to have Nikki Antonio's bill become law. I think DeWine would sign it. It's come farther. Last year she actually got hearings because she's the first openly gay member of the legislature. And she's actually been talking to people, and they didn't know it at first. And by the time they realized it, they liked her. So it's kind of hard to dismiss somebody that you like. My time is up. Thank you very much. I hope this helped, or at least piqued your imagination and it made you think about where we're going on this. Sky's open. This is an area that you can do a lot of good in. Thank you very much.